Every legal encounter leaves a trace. Every strict investigation pursues honesty. Comprehending your legal rights, establishing true justice.
Turn that damn camera off right now and show me some ID.
The camera stays on and I need to know why you stopped me first.
I don't need a reason to stop anyone in this neighborhood, sweetheart.
Actually, you need reasonable suspicion under the Fourth Amendment.
But don't get smart with me. I've been doing this since before you were...
It was a Sunday morning, and Dominique Perryman was on her way to church. She had woken up earlier than usual, had spent extra time getting ready, was wearing her best dress, and had left home with enough time to arrive before the service began. It was the kind of morning that should have had no story to tell. The kind of morning that passes and fades into memory as just another ordinary Sunday. But when she turned the corner of the street where she had lived for the past 6 years and saw the flashing lights in her rearview mirror, something in her stomach recognized it before her brain had time to process it. She pulled over. She lowered the window, and what appeared on the other side of that window was a white police officer with the expression of someone who had already decided how that conversation was going to end before it had even begun. What followed over the next 23 minutes was captured in full by Dominique's phone, which she had discreetly positioned on the dashboard before the officer reached the window. She knew how to do that, not because she was an activist, not because she had a history of conflicts with police, but because she was a second-grade detective with the Franklin County Police Department in Ohio with 12 years of service, a specialization in crimes against persons, and a record that included more than 140 successful arrests over the previous 3 years. She knew traffic stop protocols better than most academy instructors. She knew exactly what an officer should and should not do in that type of situation. And within the first 30 seconds of that stop, she already knew that what was happening had nothing to do with traffic. The image the video captured, a uniformed officer leaning over her car window, hand positioned near the equipment on his belt, mouth open in a tone that was not a question but an imposition, circulated across the country in the weeks that followed. But before arriving at the moment when that video became central evidence in a federal criminal case, there is a story that needs to be told from the beginning, about who that officer was, what he had done before that Sunday morning, and why the system that should have contained him had failed repeatedly for years before Dominique Perryman crossed his path. Before we go any further, I want to ask you something directly. Subscribe to the channel right now and drop a comment with one word that describes what you feel when you watch a video like this. It doesn't need to be elaborate. One word is enough, because stories like this exist in a space where it is very easy to consume and move on, and what I want is for you to stay, to follow through to the end. Because this particular case has an outcome that most stories like this never have, and you need to see how it got there. The officer who appears in that video was named Craig Welton. He had 14 years in the Reynoldsburg Police Department, a mid-size city in the metropolitan area of Columbus, Ohio. 14 years is enough time to build a career, to earn institutional respect, to accumulate the kind of internal political capital that protects an officer when complaints arrive. And the complaints had arrived. Not one, not two. Public records obtained during the legal process that followed the incident with Dominique revealed that Welton had accumulated 11 formal complaints over the course of his career, 7 of which involved allegations of racially discriminatory behavior during traffic stops. Of the 11, 2 had resulted in verbal warnings. The other 9 had been internally archived with no disciplinary action. Welton had learned, over 14 years, that there was a very high ceiling for what he could do without real consequences. That Sunday morning, he discovered the ceiling had disappeared. The neighborhood where Dominique was stopped was the same one where she lived, where she shopped, where she dropped her children off at school during the week. It was a neighborhood she knew by heart, where neighbors knew her by name, where she had built an entire life. There was nothing unusual about the way she was driving, the condition of her vehicle, her speed, or the lane she was in. The dash cam footage shows this clearly. The camera records completely normal, driving in the seconds before Welton's lights appear in the rearview mirror. There was no infraction. There was no legitimate pretext. There was a police officer who saw a car being driven by a black woman in a neighborhood he had patrolled for years, and decided that was reason enough to act. Craig Welton had arrived at work that Sunday morning 40 minutes early. That detail, apparently irrelevant, came to light during subsequent investigations and was cited by forensic psychologists hired by the prosecution as part of a behavioral pattern that had been documented in previous incidents. Welton had a habit of arriving early on days when he was in the mood to create problems. That was how colleagues who later testified against him described it, with the uncomfortable precision of people who had observed something for years without having the right words to name it. He would arrive early, take the patrol car alone, and head out into the neighborhood with an energy that others had learned to recognize. It was not professional enthusiasm. It was something else. It was the particular disposition of someone who was looking for a specific situation and knew it was only a matter of time before finding it. He had made 3 other stops that morning before pulling over. Dominique's car. Dispatch system records showed this with time-stamp precision. The first had been a black man driving a pickup truck toward the city's commercial district. Welton had stopped him, spent 19 minutes asking questions without issuing any infraction, and released him with no formal record. The second had been a Latina woman in a vehicle with an out-of-county plate. Same dynamic. Prolonged stop, questions with no apparent foundation, release with no documented infraction. The third had been a young black man on a bicycle, stopped on the shoulder of a road where cyclists had every right to be. Welton had stayed with him for 11 minutes before moving on. 3 stops in less than 2 hours, 3 people of color, no documented infraction in any of them. When Dominique's attorneys presented these records during the proceedings, the federal prosecutor described that morning as a pattern of hunting, not patrolling. When Welton's lights appeared in Dominique's rear view mirror, she did what any person trained in stop procedures would do. She pulled over immediately, in a well-lit location, with enough space for the officer to approach safely. There was no hesitation, no evasive maneuver, nothing that could be interpreted as lack of cooperation. She placed her hands visibly on the steering wheel and waited. In the interval between pulling over and the officer reaching the window, which lasted approximately 45 seconds, she picked up her phone from the cup holder with a deliberate movement and rested it on the dashboard, camera facing the driver's window. It was not the first time she had done this. It was a personal protocol she had developed over years, not out of paranoia, but for the same reason any law enforcement professional documents potentially problematic interactions. Because evidence is the difference between what happened and what someone decides to say happened. Welton arrived at the window with the posture the video captured, and that became the image most associated with the case in the weeks that followed. Body leaning over the window opening, right hand resting on the equipment on his belt, expression that mixed performative authority with something that people who analyzed the video described consistently as contempt. He did not introduce himself. He did not state the reason for the stop, which is basic mandatory protocol in virtually every police department in the country. He did not ask if Dominique was all right. He immediately began asking questions about where she was going, where she had come from, whether the car was hers, whether she had been drinking. It was a sequence of questions that corresponded to no known traffic infraction. You do not ask someone if they have been drinking at 9:30 on a Sunday morning without any observational basis for it, such as erratic driving behavior or the smell of alcohol. It was a fishing expedition, an attempt to find something during this conversation that would retroactively justify the stop that had already happened without justification. Dominique answered each question with precision and economy of words. She was going to church. She had left from home on the parallel street. The car was hers, registered in her name. She had not consumed alcohol. Her answers gave Welton nothing to work with, and the video captures the moment he realizes this. A pause of perhaps 2 seconds where he looks into the car, then at the document Dominique had handed over, then back at her, as if recalculating. It was in that pause that he committed the first serious legal mistake. He said, with his body camera running and Dominique's phone recording, that he had stopped her car because she did not look like she belonged in that neighborhood. He did not say there had been an infraction. He did not say driving behavior had generated suspicion. He said she did not look like she belonged there, in a neighborhood where she had lived for 6 years, on a street less than 1 kilometer from her own home. Dominique's expression at the moment. Welton said, that is one of the most discussed elements by those who analyze the video in detail. There was no explosion, no visible emotional reaction, nothing Welton could use to escalate the situation. There was a very slight shift in posture, almost imperceptible, the kind that happens when a person who already suspected something receives confirmation that their suspicion was correct. She had entered that stop as a detective, and she had just received, from the officer's own mouth with the camera running, the evidence that made the case legally incontestable before it had even ended. What happened in the minutes following that statement, the statement about her not looking like she belonged in the neighborhood, was where the stop crossed from administrative misconduct into criminal territory. Welton did not back down. He either did not grasp the weight of what he had said, or if he did, he calculated that there were not enough consequences to justify changing course. He ordered Dominique to step out of the car. There was no legal foundation for that. An order to exit the vehicle during a traffic stop requires the officer to have reasonable suspicion that there is a danger to their safety, or that there is evidence of a crime inside the vehicle. There was neither. The video itself documented that. Dominique was cooperative, hands visible, with no behavior that could be interpreted as a threat. Welton asked her to get out because it was the next step in the escalation he had initiated, not because there was any legal justification for the request. Dominique got out of the car. She made that decision consciously and deliberately, not because she was required to, but because she knew every second of that interaction was being recorded, and that her documented cooperation would make each of Welton's actions even more indefensible in the legal process she was already mentally constructing as it happened. When she stepped out of the vehicle, Welton instructed her to face the car with her hands resting on the hood. It was a search position, the kind of positioning used when there is suspicion that a person is armed or represents an immediate danger. Dominique Perryman was wearing a Sunday dress on her way to church. There was absolutely nothing in that scene that justified that positioning, but she complied. She faced her own car, hands on the hood, on a Sunday morning, on the street where she lived, being treated as a suspect for something Welton was unable to name because it did not exist. It was at that moment that one of Dominique's neighbors, a woman named Patricia Okonkwo, stepped out of her house to put something in the mailbox and saw the scene. Patricia was 63 years old, had lived on that street for 21 years, and had known Dominique since she had moved into the neighborhood. She stood on the sidewalk for a few seconds processing what she was seeing. The neighbors she knew by name, whose children she had watched grow up, standing facing her own car with her hands on the hood, while a police officer circled around her. Patricia went back inside immediately and picked up her own phone. She did not call the emergency number. She called directly to the non-emergency line of the police department and reported what she was witnessing: a woman being detained without apparent reason in front of her own home. That call was logged with a timestamp and later became part of the body of evidence in the case. Welton spent the next 7 minutes circling around Dominique's car, looking through the windows, opening and closing the trunk, with the permission she had tacitly granted by stepping out of the vehicle without protest. Another element that defense attorneys would later attempt to use, and that Dominique's attorneys neutralized by arguing that cooperation under coercion does not constitute legal consent. He found nothing. Of course he did not, because there was nothing to find. The car was clean, registered, insured, with no irregularity of any kind. When Welton finished circling the vehicle and returned to where Dominique was standing, the video captures a moment that prosecutors would later cite repeatedly in hearings as the point where administrative misconduct definitively became a crime. Welton grabbed Dominique's wrist with his hand, without warning, without justification, without any context that made that physical contact legally defensible, and repositioned her so that she was facing sideways relative to the car. It was assault. Simple, documented, indefensible. Dominique did not react physically. The restraint she demonstrated in that moment, watching the video, is of a quality that goes beyond training. It is the kind of control that comes from understanding, at a visceral level, that any physical reaction on her part in that moment, however justified, would be used to reframe the entire narrative. She stayed still, she breathed, and she said in a calm voice fully audible on the recording that he had just committed physical assault against a detective from the county police department and that the video had recorded everything. Welton stepped back one pace. His body camera recorded the moment. Dominique's phone on the dashboard recorded the moment. And Patricia Okonkwo, from the sidewalk across the street, was recording too. What happened immediately after Dominique's words was as revealing as everything that had come before. Welton did not apologize. He did not end the stop. He did not call for supervision. He stood, in silence for a few seconds, then returned to Dominique's car window, picked up the driver's license that had remained on the seat, handed it back to her, and said she was free to go. No explanation, no formal record of the stop, no document indicating that contact had occurred at all. It was as though he expected Dominique to simply take the license, get in the car, and drive away. That the implicit threat of everything that had happened in the last 23 minutes would be enough to ensure her silence. It was the same bet he had made 11 times before, with 11 complaints that had been filed away without consequences. It was a bet he had won 11 times. This time, he had lost before he even knew he was playing. Dominique Perryman did not go to church that Sunday. She got in the car, waited for Welton to move away, and sat there for a few minutes with the engine running and her hands on the steering wheel. Not because she was in collapse. She would describe that moment later in interviews as a period of deliberate organization, not emotional paralysis. She was taking inventory, mentally checking every element of what had happened, every word that had been said, every action that had been taken, in the exact order in which it had occurred, with the precision of an investigator who knew that the quality of immediate memory was a resource that degraded with time and needed to be preserved while it was still sharp. When she finished that process, she picked up the phone from the dashboard, verified that the recording was intact, saved the file in 3 different locations, and sent a text message to her direct supervisor's personal number. The message had 4 words: "I need to talk now." Dominique's supervisor was Detective Chief Marcus Alley, a man with 26 years of service who had supervised Dominique for the previous 4 years and who, by all available accounts, held for her the kind of professional respect that is built over years of working together on difficult cases. He called back in less than 3 minutes. Dominique described what had happened with the same precision she had used to organize the information in her own mind. Chronological, factual, without emotional embellishments that could be used to question the objectivity of the account. When she finished, Alley was silent for a moment. Then he said she should come directly to the department, not touch anything in the car, and that he would be there when she arrived. He also said something that Dominique repeated in every interview she gave about the case. He said this was not going to disappear and that he was going to personally make sure of that. Dominique's arrival at the department that afternoon triggered a series of procedures that the Reynoldsburg Police Department had clearly not anticipated when Craig Welton went out to patrol that morning. Because Dominique was not merely a victim with a video, she was a colleague within the same system, a detective from another department who had been stopped, humiliated, and physically assaulted by an officer while she was off duty and on her way to church. That created an institutional problem of a completely different nature from an ordinary civil complaint. There were implications for interdepartmental relations. There was the question of the credibility of testimony from a witness who was herself a law enforcement officer. And there was the video, which Marcus Alley watched 3 times in a row in a closed room before saying anything to anyone. What Alley did next was what defined the trajectory of the case in a way that Welton and the Reynoldsburg department could not have anticipated. Rather than routing the complaint through normal internal channels, the same channels that had archived 11 previous complaints against Welton without consequences, Alley went directly to the Franklin County Prosecutor's office. Not a phone call. He went in person, that same Sunday afternoon, with a copy of the video on a USB drive and a 3-page written account that Dominique had dictated while he wrote. The on-call prosecutor who received him was a woman named Andrea Voss, who had 15 years of experience in crimes against persons and who, according to accounts from those present, watched the video once, closed the laptop, and asked Alley whether the victim was willing to cooperate fully with a criminal investigation. When Alley said yes, Voss said she would open a formal investigation the following morning. The investigation that followed lasted 6 weeks and was conducted with a level of secrecy that the Reynoldsburg department itself was not informed of its existence until it was already at an advanced stage. This was deliberate. One of the prosecution's first decisions had been not to notify Welton's department until the evidence was completely preserved and the initial testimonies collected, precisely to prevent any internal institutional protection process from interfering with the evidentiary material. Investigators from the prosecutor's office obtained the body camera recordings from Welton's other 3 stops that morning, the ones that had preceded the stop of Dominique. They obtained dispatch records showing the pattern of stops without documented infractions. They collected testimony from 4 of Welton's colleagues who, when confronted with the evidence and informed they were under legal obligation to respond truthfully, provided accounts that painted a consistent portrait of an officer whose behavior had been problematic for years, and whose complaints had been systematically minimized by a supervisory chain that prioritized internal cohesion over accountability. The most devastating testimony did not come from a colleague of Welton's or from one of the previous victims the investigators had managed to locate. It came from Welton's own immediate supervisor, a sergeant named Donald Pruitt, who had signed off on the archiving of 6 of the 11 previous complaints. When confronted with the evidence and informed that the investigation had found documentation that he had been warned about Welton's behavior by other colleagues on at least 3 separate occasions before any formal complaint had been filed, Pruitt made a decision that his attorneys later described as the biggest mistake of his career. Instead of invoking his right to remain silent, he began to talk. And what he said over the following 2 hours not only confirmed the pattern of institutional protection the prosecution was trying to document, it provided details the prosecution had not yet found, and that expanded the scope of the investigation in a way no one had anticipated when everything had begun with a traffic stop on a Sunday morning. What Donald Pruitt revealed in those 2 hours of testimony transformed what had begun as an investigation of individual misconduct into an investigation of institutional conspiracy. He described an informal but deliberate system within the Reynoldsburg Police Department where complaints against certain officers, specifically officers with years of service, with established relationships with department leadership, and with the kind of case closure record that made their presence institutionally valuable, were managed in ways designed to minimize formal consequences. It was not a system written down anywhere. There were no memos, no explicit guidelines, nothing an external auditor could find in a document review. It was a culture transmitted through informal conversations, through verbal guidance on how to document complaints in ways that reduced their apparent severity, through decisions made in off-agenda meetings that left no trace in the department's official records. Pruitt described specifically 3 episodes involving Welton that he had personally handled. In the first, 2 years before the incident with Dominique, a black man had filed a formal complaint describing an almost identical stop, pulled over without infraction, kept for more than 20 minutes, subjected to baseless questions, and released without any record. The man had recorded part of the interaction on his phone, but the video quality was poor and the audio was partially inaudible. Pruitt admitted that he had advised the man during the complaint phase to consider whether he was certain of what he had seen, had suggested there might be a misunderstanding about police procedures, and had framed the complaint in the internal records in a way that classified it as a dispute of interpretation rather than an allegation of discrimination. The complaint had been archived within 3 weeks. In the second episode, 18 months before the incident with Dominique, a Latina woman had filed a complaint alleging that Welton had made comments about her appearance and origins during a traffic stop. There was a witness. The woman's teenage son had been in the passenger seat throughout the interaction. Pruitt had interviewed the boy separately from his mother, without the presence of an adult guardian other than the witness himself, which was a violation of departmental protocol for interviews with minors. During that interview, according to Pruitt himself in the deposition, he had framed the questions in a way that suggested the boy might be confusing the officer's tone with ordinary rudeness rather than intentional discrimination. The complaint had been archived within 2 weeks. The third episode was the most serious of all and involved an allegation of disproportionate physical force that had been completely excluded from the department's formal records. Not archived as unfounded, but simply not recorded as having existed at all. Prosecutor Andrea Voss, upon receiving Pruitt's testimony, made a decision that expanded the scope of the charges in a way the Reynoldsburg Department had not anticipated when the case had begun. She added Pruitt as a secondary defendant in the criminal charges, not as a collaborative witness. And she based that decision on a legal doctrine that is rarely applied in police misconduct cases, but which, when applied, has devastating consequences for everyone involved. The doctrine of liability through deliberate omission, which establishes criminal responsibility for supervisors who, having knowledge of a pattern of criminal conduct by a subordinate, take active steps to prevent that pattern from being investigated or punished. It was not negligence, it was complicity. And Pruitt's 2 hours of testimony had provided the prosecution with exactly what it needed to sustain that argument before a jury. The formal charges against Craig Welton, were filed 53 days after the incident in the Columbus residential neighborhood. There were 6 charges in total. Discriminatory stop with racial motivation, which was a crime under Ohio state legislation, reformed following a series of documented racial profiling cases in the state in previous years. Physical assault against a public safety officer, which carried an aggravating factor because Dominique was a law enforcement officer, even while off duty. Abuse of authority, falsification of public record, for the deliberate absence of any documentation of that stop in department records. Obstruction of justice related to the way Welton had attempted to end the interaction without leaving a trace after Dominique mentioned the video. And the 6th charge, the one that transformed the case from administrative to definitively and irreversibly criminal. Second-degree kidnapping, because detaining a person by force without legal cause constitutes unlawful deprivation of liberty under the Ohio Penal Code, regardless of how long the detention lasted. When the charges were made public, the Reynoldsburg Department issued a statement saying Welton had been suspended without pay pending the conclusion of the legal process. It was a late defensive response, accompanied by a series of statements from department attorneys, attempting to establish distance between the institution and the individual officer's actions. Exactly the kind of dissociation that Pruitt's inclusion as a defendant made legally unsustainable. Because if a supervisor had actively protected Welton from consequences for years, the institution could not claim that Welton's actions were individual and isolated. The chain of responsibility went up, and the prosecution was determined to follow that chain wherever it led. Craig Welton's trial began on a Monday in March, 8 months after that Sunday when he had stopped Dominique Perryman's car in a residential neighborhood of Columbus. The courtroom was full. Not because there was a crowd of protesters or because the case had become a media spectacle in the most superficial sense of the word, but because there was an unusual number of people with a direct stake in the outcome. Previous victims the investigators had located, colleagues of Dominique from the Franklin County Department, representatives of civil rights organizations that had followed the case since the charges were made public, and a significant number of residents from the neighborhood where the stop had occurred, including Patricia Okonkwo, who had reserved a seat in the front row and who was present on each of the 11 days of trial without exception. Welton's defense strategy had been built on 3 pillars that his attorneys probably knew were fragile, but that were the only ones available given the quality of the evidence. The first pillar was to question the chain of custody of the recordings, to attempt to establish that there was a technical possibility that the video from Dominique's phone had been edited or manipulated between the moment of recording and the moment it was presented as evidence. That line of argument was destroyed in the second hearing, when the prosecution's technical experts presented forensic analysis of the video file that verified its integrity frame by frame, confirming there was no evidence of editing or manipulation of any kind. The second pillar was to argue that the order to exit the vehicle had been justified by security elements not visible in the video, but that Welton had perceived in person. That argument collapsed under cross-examination when the prosecuting attorney asked Welton specifically what security elements he had perceived, and the answers were so vague and internally inconsistent that the jury itself was observed exchanging glances during the testimony. The third pillar was the most desperate of the 3 and revealed just how short of real options the defense had run. Welton's attorneys attempted to argue that the physical contact, the assault for which he had been charged, had been an involuntary gesture, a positioning adjustment necessary for the safety of the procedure, not an intentional assault. That argument needed to survive the video. It did not. Prosecutor Andrea Voss, during closing arguments, paused the video on the exact frame in which Welton's hand grabbed Dominique's wrist, and left that image frozen on the screen for 27 seconds of complete silence before saying anything. When she spoke, she said only that the jury had seen what they had seen, that no verbal explanation could undo what was documented in that frame, and that the question before them was simple, whether that was, or was not, the definition of unprovoked physical assault against a citizen, who was cooperating fully with a stop that should never have happened. The jury deliberated for 2 days, not because there was doubt about the outcome, but because there were 6 separate charges, and the jury foreperson was a meticulous woman who insisted that each charge be analyzed individually with specific reference to the corresponding evidence before any vote was conducted. When they returned with the verdict, Craig Welton was found guilty on all 6 charges. The room fell silent for a moment after the foreperson finished reading. Then Patricia Okonkwo, in the front row, put her hand over her face, and Dominique, seated beside her attorneys, remained completely still for a few seconds before briefly closing her eyes and opening them again with the expression that people who were present later described not as relief, not as triumph, but as the face of someone who had carried something very heavy for a very long time and had just been given permission to set it down. And sentence was handed down 6 weeks after the verdict. The judge who presided over the case was known for sentences that balanced punishment with proportionality, and there was a genuine expectation that Welton would receive something at the lower end of the range permitted by the charges. That expectation was quickly revised when the judge began reading the sentence. He spoke for 42 minutes before arriving at the number. He spoke about what the case represented in terms of abuse of public trust. He spoke about the pattern of 11 archived complaints and what that said about the institutional complicity that had allowed Welton to continue operating without consequences. He spoke about the specific impact on Dominique Perryman, not just the trauma of the incident itself, but what it means for a woman who dedicated her career to serving and protecting to be treated as a suspect by the very system to which she had devoted 12 years of her life. And then he arrived at the number. 5 years in state prison, with no possibility of early release in the first 30 months, followed by 3 years of supervised parole, immediate and permanent dismissal from the position, with irrevocable revocation of police certification in the state of Ohio. Donald Pruitt, prosecuted separately, received 18 months in prison and dismissal under the same conditions. Dominique Perryman gave a single press conference after the sentencing, outside the courthouse, with Marcus Alley by her side. She spoke for less than 5 minutes. There was no anger in those words, no performative victory, nothing that sounded like celebration of another person's suffering. There was clarity. She said there were 2 stories this case told simultaneously, and that it was important not to confuse one with the other. The first was the story of what had happened to her. A woman on her way to church on a Sunday, stopped without reason, humiliated on her own street, who had fought for what? Was right because she had the means to do so. The second was the story of all the people who had gone through something similar with Welton before her, whose complaints had been archived, whose names had never appeared in a newspaper headline, and who had not received any verdict in a courtroom that day. She said what had happened in that courtroom was justice for her, but that real justice meant the system that had protected Welton for 14 years should never function that way for anyone again. And that part, the systemic change, the real reform, the guarantee that the next 11 complaints would not be silently archived, that part had not yet happened. That part was still to come.
All right, let's make this simple. Show me proof you're in this country legally.
And what authority do you have to ask me that while I'm filling up my
If you
car?
don't prove you're a citizen right now, you're going to
I'm a
cuffs.
citizen and a lieutenant with 11 years.
At a gas station on an ordinary afternoon, a black man in a plain t-shirt was leaning against a pump filling up his car. Nothing about that scene was unusual. It was the kind of stop anyone makes dozens of times a year without a second thought. Get out of the car, insert the card, wait for the tank to fill, move on. The sky was clear, the station was busy, and there were other cars and other people around. There were no sirens, no chase, no context that would justify what happened next. 2 ICE agents, Immigration and Customs Enforcement, approached him in full tactical gear, ballistic vests, rifles, faces covered by masks, and blocked the exit with the posture of people surrounding a dangerous fugitive. The body camera of one of the agents captured the exact moment when one of them looked at the man and said, with the ease of someone who believes they are in complete control of the situation, "All right, let's make this simple." What those agents didn't know in that moment, and what the body camera recorded in real time as the situation unfolded, was that the person they had cornered at a gas station with military-grade equipment was Lieutenant Kemba Davis, a black police officer with more than 15 years of service in a metropolitan police force in the American South. She was off-duty. She was in civilian clothes. She was doing exactly what any ordinary citizen would do on a weekday afternoon. And she was about to experience one of the most absurd and revealing moments any law enforcement officer has ever faced on American soil. Being treated by colleagues within the same system as though she were an undocumented immigrant based on absolutely nothing other than the color of her skin. The story of Kemba Davis is not a story about immigration. It is not a story about ICE procedures or border policy or any of the debates that usually dominate conversations when that agency's name appears in the news. It is a story about what happens when racial prejudice is so deeply embedded in a system that it operates automatically without requiring conscious intent, without requiring a declared villain, without requiring any trigger other than a person's appearance. It is a story about how two armed federal agents at a busy gas station looked at a career law enforcement officer and saw something entirely different from what she was. And it is a story about what happened after footage of that moment became public. Before we go any further, I want to ask you something. Subscribe to this channel right now and drop a comment telling me what city you're watching from. Because this story is not an isolated case from a specific state or a specific department. It is a pattern that repeats itself in places, in situations you may have witnessed without fully understanding what was in front of your eyes. And this particular story has a level of documentation and legal consequences that makes it one of the most important cases in recent years for understanding how institutional prejudice operates in practice, not in theory. ICE was created in 2003 as part of the reorganization of the Department of Homeland Security following September 11th. Its stated mission is to enforce federal immigration laws and protect national security. ICE agents have the authority to approach, detain, and arrest people suspected of immigration status violations. But that authority has very specific legal limits. They need reasonable basis to believe a person is undocumented before initiating any compulsory contact. What they cannot do, legally, is approach people randomly based on racial profiling, which means the central question at that gas station was not whether Kemba had documents, it was what specifically had led those two agents to approach her in the first place. And when that question was asked during the legal process that followed, the answer revealed something the department would have much preferred to keep out of the public record. The body cam footage from that day runs less than 4 minutes, but each of those minutes contains layers of information about how power operates, about how authority is distributed unequally, about the gulf that exists between what institutions say they are and what they demonstrate themselves to be when the camera is running, and no one has yet realized that the person being approached has the means to transform that moment into a federal lawsuit. In 4 minutes, two agents built the case against themselves without realizing it. And Kemba Davis, with the composure of someone who spent 15 years knowing exactly how to behave when everything around them is going wrong, let them do it. It was a Thursday in October when Kemba Davis stopped at that gas station in the metropolitan area of Savannah, Georgia. She had left earlier than usual that day because she had a medical appointment and needed to fill up before getting on the highway. She was wearing jeans, a dark blue t-shirt, and sneakers. The clothes of someone who is off duty, who has nothing to prove to anyone, who is living the kind of anonymous and inconsequential afternoon that everyone deserves to have once in a while. She inserted her card into pump number 4, selected her fuel grade, and was waiting for the tank to fill when she caught out of the corner of her eye 2 unmarked black vehicles pulling into the station at a speed and angle that were not those of someone who came to get gas. The 2 agents who stepped out of those vehicles were wearing equipment more appropriate for a high-risk operation in a conflict zone than for an approach at a commercial gas station on an ordinary afternoon. Full tactical vests, rifles at the ready, faces covered by masks, active radios. The agent leading the approach was named Derek Hollis, with 6 years at ICE, most of them in field operations across the southeastern United States. The agent accompanying him was Sarah Pruitt, with 4 years at the agency. Both were part of a special operations unit that had received that day a location order for a specific suspect, an undocumented male immigrant, approximately 35 years old, who had been seen in the area driving a dark-colored vehicle. That was the profile. Vague, imprecise, no photograph, no full name, no identifier that could distinguish the person from any other human being who loosely matched that description. Kemba was 38 years old. She was in a dark vehicle. She was in an area that coincidentally overlapped with the search zone the unit had been assigned. And she was black. That was enough. Hollis and Pruitt made no further checks before approaching. They did not. Run the vehicle's license plate through the database. which would have immediately revealed that the car was registered to an American citizen with no record. They did not observe the person long enough to notice that her behavior was completely inconsistent with someone trying to avoid federal attention. They did not consider the possibility that the description they had was so generic it applied to a significant portion of the population of that city. They saw what their bias was programmed to see, and they acted on it. Hollis's body camera had been running since the moment he stepped out of the vehicle. The footage shows both agents approaching pump number 4 with Kemba between them and the gas station behind her. It shows Hollis positioning his body to block her left side while Pruitt covered the right. It shows Hollis's rifle not aimed, but in a position that anyone with training would recognize as immediate readiness. The difference between that position and a direct aim was a fraction of a second of decision, and it shows Kemba's face in the moment she realizes what is happening. There is no panic in that face. There is recognition, the kind of recognition that comes from years of training and from a lifetime of understanding that certain moments demand absolute control, regardless of what you are feeling on the inside. Hollis got straight to the point. He said he was looking for someone and needed to verify her identity. He used the tone agents use when they want the other person to understand there is no room for negotiation. Not aggressive in the sense of shouting or explicitly threatening, but with that calculated firmness that is designed to communicate that compliance is the only available option. Kemba responded with a composure that, watching the video, is almost difficult to believe. She asked, directly and without hostility, what the legal basis was for that stop. She did not give her name yet. She did not present identification yet. She asked for the legal basis because she knew exactly what was happening, knew exactly what her rights were, and knew exactly that that question had the power to reveal, in the agent's own words, whether or not there was any foundation for that interaction. Hollis did not have a good answer to that question. What he had was the mission order, the vague suspect profile, and the assumption that the person in front of him was not in a position to challenge federal authority at a gas station with 2 armed agents blocking the exit. What he did not have was probable cause. What he did not have was reasonable suspicion based on specific and observable behavior. What he did not have was any concrete element connecting Kemba Davis to the suspect he was looking for, beyond general physical characteristics that described thousands of people in that city. And when he attempted to articulate a justification, what came out was exactly the kind of vague and circular response that Kemba's attorneys would later use to demonstrate that the stop had never had legal foundation from its very first second. There is a specific moment in the body cam footage that civil rights attorneys described as the turning point of the entire case. Not the moment of the initial approach, not the moment Kemba asks for the legal basis, but the moment that comes right after, when Hollis realizes his answer was not sufficient and decides to escalate. Rather than stepping back, rather than reassessing whether there was any real foundation to continue that interaction, he did what agents in positions of authority frequently do when they feel control of a situation slipping from their hands. He increased the pressure. He told Kemba that her cooperation was necessary for everyone's safety, that the situation could be resolved quickly if she simply provided her documents, and that refusing to cooperate with federal agents on duty could have serious consequences. It was intimidation language built to make the other person feel that the only reasonable way out was to comply, and it would have worked with most people. Kemba was not most people. 15 years in a metropolitan police force, including 6 years in a violent crimes unit where high-pressure situations were the norm rather than the exception, had given her an ability to keep a clear head in circumstances that would cause most civilians to fall apart. She knew intimidation language because she had herself learned to use it as a professional tool. She knew when an approach had legal foundation and when it was theater. And what Hollis was doing in that moment was theater. She responded with a statement the video captured with complete clarity, and that became, in the weeks that followed, perhaps the most shared sequence of the entire footage. She said she understood what he was trying to do, that she respected his role, but that she was also a law enforcement officer, that she knew her rights, and that he needed probable cause to demand her identification, which he clearly did not have. Hollis's reaction to that response revealed something fundamental about the mindset that had guided the approach from the beginning. He was visibly thrown off, not angry, at least not explicitly, but with that particular expression of someone who has built a mental script for how a situation should unfold, and suddenly realizes the other person is not following the script. He had arrived at that gas station with a very specific expectation of how that interaction would work. Someone would be approached, would be intimidated by the presence of two armed federal agents in tactical gear, would immediately provide documents, would be checked in the system, and the situation would be resolved in minutes. No part of that script included the possibility that the person being approached would know the law better than he did and have the training to articulate it precisely in the middle of an armed stop. It was at that moment that Pruitt, the agent who had stayed in the background until then, entered the conversation. And the way she entered revealed that there was a real disconnect between the two agents about how to proceed. Pruitt did something Hollis had not done. She asked Kemba directly whether she was an American citizen. She did not ask for documents. She did not assert anything. She asked. It was a slightly different approach, and anyone with interrogation experience would recognize that Pruitt was trying to find a way out of the situation Hollis had created without openly admitting the stop had no foundation. Kemba replied that yes, she was an American citizen, born in Atlanta, Georgia, and that she was a lieutenant in the Metropolitan Police. Then, and only then, she slowly reached into her back pocket, removed her wallet, and presented her police identification. The silence that followed lasted perhaps 3 seconds on the video, but those who have watched the footage describe those 3 seconds as the moment you can see, in real time, two agents simultaneously processing the weight of what had just happened. Hollis looked at the identification, looked at Kemba, looked at Pruitt, and then looked at the camera on his own chest, as if remembering for the first time since he had stepped out of the vehicle that all of this was being recorded. It was not the discovery of the credentials that was written on his face in that moment. It was the calculation, the instantaneous and involuntary reassessment of everything that had been said and done since he arrived at the station, being reprocessed now through the lens that the person in front of him had legal authority equivalent to his own, and the means to use every second of that video against the department. Pruitt was the first to speak after the silence. She began saying there had been a misunderstanding, that they were running an operation in the area, that the suspect profile had generated the approach, that there had been no intention of causing any kind of embarrassment. It was the beginning of an apology constructed with the calculated precision of someone who knows they are on very dangerous ground and is trying to find the right words to minimize the damage before the situation escapes completely from their control. Kemba let Pruitt finish. She did not interrupt. She did not display satisfaction or anger or any emotion that could be used to reframe what was happening. When Pruitt finished speaking, Kemba did something very simple. She asked if she was free to go, and when Hollis said yes, she returned the identification to her wallet, the wallet to her pocket, removed the fuel nozzle from the tank with the care of someone finishing an interrupted task, got in her car, and left the station. Hollis's camera followed the vehicle until it disappeared from view. Kemba Davis drove in silence from the gas station to her home. She canceled her medical appointment. She went inside, sat at the kitchen table, and stayed there for a period of time she later described in interviews as difficult to quantify. Not because she was in emotional collapse, but because she was doing something that 15 years of training had prepared her to do in critical situations. She was organizing, reconstructing the sequence of events in chronological order in her own mind, identifying each relevant moment, assessing what she had and what she would need to transform that experience into something that could not be dismissed as a misunderstanding or an isolated incident without consequences. She knew that what had happened at that gas station had a precise legal name. She knew she had evidence in video format that no defense attorney would likely be able to neutralize. And she knew that the decision she was about to make would determine whether that incident ended. As another episode swallowed in silence, or as a lawsuit with real consequences for real people and real institutions. She called the police union that same afternoon, not to seek emotional support or to report the incident informally. She called to speak with the on-call attorney and begin the formal documentation process. She described every detail with the precision of someone giving a deposition: time, location, identification of the agents, exact sequence of events, specific words used, positioning of the agents, status of the weapons. The attorney who took her call interrupted her narrative twice, not to ask questions, but to confirm he had correctly understood what he was hearing. The second time he interrupted, he said something that Kemba later repeated in interviews, as the moment she fully understood the dimensions of what she had. He said that what she was describing, if confirmed by the footage, was one of the clearest cases of racially motivated stops by federal agents he had seen in 23 years of labor and civil rights law. The formal request to preserve the body camera footage from Hollis and Pruitt was filed within 2 hours. Simultaneously, the union notified the Metropolitan Police Department, where Kemba served, about the incident, which triggered a series of institutional procedures that ICE had clearly not anticipated when its 2 agents stopped at that gas station that afternoon. Because Kemba was not merely a citizen with violated constitutional rights, she was an active police officer, which meant the incident crossed jurisdictions, involved interinstitutional relations between different public safety agencies, and had implications that extended well beyond an individual's civil action. The Metropolitan Police Chief was personally notified, and his reaction, according to people who were present at that meeting, was one of an indignation that required no rhetorical construction to be genuine. ICE, upon being formally notified of the complaint, initially responded with the standard protocol of any federal agency facing a misconduct allegation: acknowledgement of receipt, opening of an internal investigation, indeterminate timeline for conclusion, language carefully constructed to neither admit nor deny anything before the facts were internally assessed. It was a response that anyone familiar with how these agencies operate would immediately recognize as a damage containment strategy, not a genuine commitment to transparency or accountability. But there was one element in this specific case that made the standard wait-and-see strategy far more dangerous than usual. The body cam footage was ICE property, but the preservation request had been legally filed before any internal decision about the fate of that material could be made. And Kemba's attorney had made absolutely clear in the notification that any alteration, degradation, or loss of that material would be treated as obstruction and added to the action as an aggravating element. 3 weeks after the incident, the footage was released, not voluntarily by ICE. It was obtained through a formal request under the Freedom of Information Act, and when the video was watched for the first time by Kemba's attorneys in a conference room at an Atlanta law firm, what they found was more than they had expected, not only because the footage confirmed every detail Kemba had reported, but because it showed additional elements she herself had not been able to see at the time. Camera angles revealing the exact positioning of the agents, the posture of the weapons, Hollis's expression in the seconds following the presentation of her credentials. It was material that, in the words of the lead attorney on the case, made the ICE defense not merely difficult, but virtually impossible to construct on any argument other than admitting the stop had been a serious mistake. When the video became public weeks later, the reaction was immediate and of an intensity that ICE was clearly not equipped to manage. It was not just social media outrage, though there was plenty of that. It was national news coverage framing the case not as an isolated incident, but as evidence of a systematic pattern of racially motivated stops by ICE agents that had been documented across multiple states in previous years. It was members of Congress demanding formal explanations from the agency's director. It was the ACLU issuing a statement citing Kemba's case as an example of a practice requiring urgent congressional investigation. And it was, above all, the image in that video: 2 armed federal agents blocking a black woman at a gas pump with the caption, "All right, let's make this simple," frozen on the screen. That had the kind of visual clarity that requires no additional narration to communicate what was wrong with that scene. The lawsuit was filed in the federal court for the Southern District of Georgia 42 days after the gas station incident. The document was 97 pages long. It was not the kind of petition rushed together by an attorney who had just heard their client's story and was betting on a quick settlement. It was the kind of document that revealed weeks of meticulous work, every allegation anchored in specific jurisprudence, every violation connected to established federal precedents, every element of the video referenced with precise timestamps and corresponding technical analysis. Kemba's attorneys had built a case that operated on multiple layers simultaneously, and each layer was independently devastating for ICE's position. The first layer was the most straightforward, the Fourth Amendment. The stop had occurred without probable cause, without reasonable suspicion based on specific and observable behavior, and without any concrete element connecting Kemba to the suspect. The agents were looking for beyond general physical characteristics shared by an enormous portion of the population. The petition cited Supreme Court precedents that had clearly established that racial profiling alone never constitutes reasonable suspicion, that vague correspondence with a generic description does not justify a detention, and that the use of disproportionate, intimidating force in a baseless approach amplifies the constitutional violation rather than mitigating it. Each of those precedents was applied directly to the facts documented in the video, creating a line of argument that any federal judge with civil rights experience would immediately recognize as solid. The second layer was the Fifth Amendment, protection against compulsory self-incrimination and guarantee of due process. The attorneys argued that the language Hollis used during the stop, specifically the references to the serious consequences of not cooperating with federal agents, constituted coercion, designed to force Kemba to provide information without due process of law. This layer of the argument was more technical, harder to communicate to a lay jury, but was potentially the most costly for ICE in terms of precedent, because if the court accepted that interpretation, it would effectively be saying that the standard language used by ICE agents in field stops constituted unconstitutional coercion in a systematic way, not just in that specific case. The third layer was where the case became truly historic. Kemba's attorneys had done something few firms would have the resources and willingness to do. They hired investigators to research the complaint history against the specific ICE unit to which Hollis and Pruitt belonged. What they found transformed the case from an individual action against two agents into a systemic action against an entire unit and against the supervision that had allowed a pattern of racially motivated stops to develop without consequences. There were records of at least 16 formal complaints against agents from the same unit in the previous 3 years, all involving stops of Black or Latino individuals without documented probable cause. Of the 16, 14 had been internally archived with no disciplinary action. One had resulted in a verbal warning. One had been referred for external investigation and then quietly discontinued. 16 complaints. 0 real consequences. It was the type of pattern that transforms an individual action into institutional liability. And institutional liability carries a financial cost of a completely different order of magnitude. The Department of Homeland Security, under whose supervision ICE operates, was added as a secondary defendant in the action. This was strategically significant for 2 reasons. First, because it expanded the potential financial liability beyond the resources of a single operational agency. Second, and more importantly, because it forced the involvement of a supervisory level that normally remains insulated from the consequences of individual field actions. The federal government defense attorneys assigned to the case made an initial assessment that was described by sources close to the process as concerning for the government. And that is a description government attorneys rarely use about cases they consider manageable. The video was incontestable. The unit's history was documented. Kemba's identity as a police officer with verifiable credentials made any argument that there had been reasonable ambiguity in the situation impossible, and the national coverage of the case had created a level of public visibility that made any attempt at a quiet resolution politically unviable. During the discovery phase, Kemba's attorneys requested documents that the government initially attempted to block under a claim of deliberative process privilege, a legal doctrine that protects internal government agency communications related to the policymaking process. The court partially denied that claim and ordered the disclosure of a series of internal communications exchanged between unit agents, supervisors, and agency attorneys in the weeks following the incident. What those documents revealed was, in the words of the judge overseeing the case at a hearing that became public, sufficiently concerning to warrant an independent investigation beyond the civil action. The communications showed that unit supervisors had been informed about the incident with Kemba the following day, that at least one supervisor had internally described the situation as a misidentification that could be managed, and that there were discussions about how to frame the incident in internal reports in a way that minimized the appearance of misconduct. It was not obstruction in the most technical sense of the term, but it was evidence of an institutional culture that prioritized protecting the agency over holding agents accountable, and that had implications that extended well beyond that specific case. Settlement negotiations began before the case came anywhere close to trial, and the federal government initiated the conversations, not Kemba. That detail matters because it inverts the dynamic that normally characterizes these processes. In cases involving powerful federal agencies on one side and individual citizens on the other, it is almost always the plaintiff who feels the pressure of time, litigation costs, and the emotional exhaustion of a prolonged legal battle, and who eventually accepts a lower value than they deserved, just to bring it to an end. The government counts on that. It builds its strategy around it. It drags the process out, multiplies procedural demands, raises the cost of each stage until the other party simply no longer has the endurance to continue. But Kemba had the police union funding the action, had a law firm that had identified the historic potential of the case and was willing to go all the way, and had a video that became more devastating to the government's position every time it was watched. The government blinked first. The initial proposal the federal attorneys placed on the table was rejected by Kemba's attorneys without prolonged negotiation. It was a number the government's lawyers probably knew would be rejected, the kind of opening offer that functions as a probe, trying to gauge the other party's desperation before revealing how much they are actually willing to pay. The response from Kemba's attorneys was a counter-document that not only rejected the figure, but formally expanded the scope of the non-financial demands in the settlement in a way that made clear the case had never been primarily about money. The demands included the termination of Hollis and Pruitt, the permanent revocation of both agents' federal certifications, the opening of an independent investigation into the 16 previous complaints archived without disciplinary action, the implementation of a revised training program for the entire unit, with annual external auditing, and the creation of an independent oversight mechanism for field stops conducted by ICE tactical units in the southeastern region. The government resisted several of those demands. The termination of both agents was the one that generated the most prolonged negotiation, not because the government believed Hollis and Pruitt were defensible in the face of the evidence, but because conceding on that point opened a precedent that other federal agencies feared. If ICE agents could be terminated as a direct result of a civil action for racial profiling, that created a replicable legal pathway that civil rights attorneys across the country could use in similar cases. It was a precedent the government wanted to avoid at any cost, and Kemba's attorneys knew that and used that knowledge as leverage during negotiations. Every time the government retreated on the termination issue, Kemba's attorneys responded by increasing the financial figure being sought. Of this, and the message was simple. The protection of the precedent you want to maintain has a price, and that price increases with every round of negotiation that does not result in an agreement. The final settlement was signed 11 months after the gas station incident. The full amount was never publicly disclosed, but partial public records and sources close to the process indicated it was substantially above $2 million, with some estimates reaching $4 million when including litigation costs and attorney fees covered by the government. Hollis and Pruitt were terminated. The federal certifications of both were revoked, preventing rehire by any federal security agency. The independent investigation into the 16 prior complaints was opened and resulted, months later, in disciplinary actions against 3 supervisors who had archived complaints without adequate investigation. The revised training program was implemented, and the independent oversight mechanism, though in a more limited form than Kemba had originally requested, was established as a binding part of the settlement. What happened to Kemba afterward followed a path that people who knew her described as completely consistent with who she had always been. She went back to work. She remained a lieutenant. She did not request a transfer, did not seek accelerated promotion using the case's visibility as a stepping stone, did not become a public figure beyond what was necessary to ensure the story was told accurately. She gave selected interviews to outlets that demonstrated a commitment to covering the case in its entirety, and not just its most sensational aspects. And in each of those interviews, she said versions of the same thing that Irvo Otieno had said months earlier, in a different case, in a different state, with superficially distinct but structurally identical circumstances. She said she won not because the system worked for her, but despite the system, that she had resources, training, and specific circumstances that placed her in a position to fight, and that for every person in that position, There were hundreds who did not have those tools and who simply absorbed what had been done to them and moved forward because the alternative seemed impossible. There is a line that connects the case of Kemba Davis to the case of Irvo Otieno and to dozens of other documented cases in recent years where law enforcement officers were racially profiled by their own colleagues within the same system while off duty. That line is not coincidence, it is pattern, and what these cases have in common, beyond the race of the people approached and the absence of any legal justification for the stops, is that all of them only resulted in real consequences because the people involved had the knowledge, the resources, and the determination to transform a humiliating experience into a documented legal action. The system did not correct itself because it recognized it was wrong. The system, it was forced to respond because someone had the power to force it. And that distinction between voluntary correction and compulsory accountability is perhaps the most important thing anyone watching these stories can carry with them when the video ends.
Sir, step away from the mailboxes, please.
Good morning, officers. I am U.S. Postal Inspector Vincent Marshall.
You are a what?
Postal Inspector. I am investigating the mail theft complaints in this neighborhood.
Where's your uniform? Your postal vehicle?
Postal inspectors are federal criminal investigators. We work.
It was a Sunday afternoon, October 22nd, 2023. The sun was still high over Tennessee, and the neighborhood of Collierville had that look of a place where nothing ever happens. Well-kept lawns, two-story brick houses, wide, quiet streets where the loudest sound is usually a sprinkler system running on a timer. It was the kind of community where people leave their cars in open garages and don't bother locking the front door. A place built, at least in appearance, on the idea that everything is fine. Irvo Otieno left his house around 2:30 in the afternoon. He was well-dressed, blue blazer, slacks, dress shoes. Not because he had somewhere to be, but because that was simply how he carried himself in the world. 18 years in the United States Postal Inspection Service had left him not just with commendations and a flawless career, but with a way of presenting himself that came from within. He walked across his own front yard, made his way to the communal mailbox installed on the sidewalk of his development, and used the key on his keychain to open the compartment assigned to his unit. It was a gesture he probably repeated 3 or 4 times a week without a second thought. Picking up the mail, nothing more ordinary than that. That was the exact moment the patrol car appeared. 2 officers from the Collierville Police Department responded to a call from a neighbor who had reported what they described as a suspicious man tampering with the mailboxes in the development. The man in question was wearing a suit, standing in front of a house worth close to $1 million in a gated community using a key. But the neighbor called, and the officers came. And when they arrived, they didn't see a resident picking up his own mail. They saw what they had decided to see before they even opened the patrol car door. What happened in the minutes that followed was captured by both officers' body cameras, and the footage that became public months later triggered a reaction that spread across the entire country. Because in that video, you can clearly see the moment when a man who had dedicated nearly 2 decades of his life to protecting the American postal system found himself being treated like a criminal in front of his own home. You can see the expression on his face. Not fear, but something deeper. The look of someone who already knows exactly what is happening and exactly why. Before we go any further, I want to ask you something. Subscribe to this channel right now, because this story gets heavier by the minute, and you're going to want to follow it all the way through. And tell me in the comments, have you ever been stopped, or watched someone get stopped, for absolutely no real reason? Because what Irvo experienced that Sunday is not an exception. It's a reality that a lot of people know firsthand. The United States Postal Inspection Service is one of the oldest federal agencies in the country, founded as far back as the 18th century. Postal inspectors carry full federal authority. They can make arrests, execute warrants, carry firearms, and investigate crimes that cross state lines. Irvo Otieno was not a mail carrier delivering packages. He was a career federal agent with credentials that placed him at a level of authority equivalent to an FBI agent. He had investigated fraud cases worth tens of millions of dollars. He had worked cases involving organized crime, narcotics trafficking through the postal system, and money laundering. 18 years building a record that very few people ever achieve. And there he stood, with officers examining his hands, being questioned about whether he had the right to pick up his own mail in a neighborhood where he paid a mortgage, in a development where his name was on the deed, on a Sunday afternoon, where the only thing he had planned to do was check whether anything important had arrived in his mailbox. This case became a federal lawsuit worth millions. It became a national conversation about structural racism and the use of disproportionate force. It became mandatory training material for police departments across multiple states. But before it became any of that, it started exactly like this, with a black man, well-dressed, in an affluent neighborhood, doing the most common and harmless thing in the world, and being treated as a threat simply for existing in that space. The two officers who responded to the call that afternoon were Detective Brian Chandler and Officer Kyle Samples. They arrived on the scene in less than 10 minutes after the neighbor placed the report. And here, it's worth pausing for a moment to understand what exactly was said in that call, because it matters. The neighbor didn't report a window being forced open, didn't report anyone fleeing with mail tucked under their arm. There was no evidence of a crime taking place. What the neighbor said, in essence, was that there was a black man in a predominantly white neighborhood, doing something that didn't register to them as belonging in that space. That was enough to trigger a police response. When Chandler and Samples arrived, Irvo was still near the mailbox. He wasn't running. He wasn't acting evasively. He was simply standing there, in a suit, holding his mail, the way any resident would. But the approach didn't begin with a casual question or a professional introduction. It began with both officers positioning themselves to block Irvo's exit, treating him as a suspect in a serious crime before a single word had been exchanged. The body cameras recorded everything from the very first second. What the footage shows is disturbing, not because of any explicit violence, but precisely because there is none. There were no punches thrown, no weapon drawn, nothing the world could label as police brutality in its most obvious terms. What there was instead was something more subtle and, in some ways, more revealing. It was the treatment. It was the tone. It was the automatic assumption of guilt that was visible in every question asked, in every instruction given, in the way the two officers moved around Irvo as though he were a potential threat that needed to be contained before being understood. Irvo Otieno was treated like an intruder in the very neighborhood where he lived because someone, somewhere, looked out a window and decided he didn't look like he belonged there. Irvo identified himself, said he lived there, said he was picking up his own mail, pointed to his own house, visible just a few meters away, gave his address. And still the officers continued the stop. They asked for documents. They demanded that he prove he had a right to be in that location. And it was at that moment that Irvo made a decision that would define the next several months of his life. He didn't escalate. He didn't raise his voice. But he didn't back down either. He walked to his car, retrieved his wallet, and presented his federal credentials from the United States Postal Inspection Service. The officer's reaction to seeing those credentials was captured on camera. And it was not the reaction of someone who had just understood they had made a serious mistake. It was the reaction of people who were thrown off for a second, recalibrated, and tried to find a way out that didn't include admitting anything. Instead of ending the stop immediately, as any minimally, reasonable protocol would require, when facing an identified federal agent, both officers continued asking questions, continued treating Irvo as though the credentials were something to be verified rather than accepted, as though a black man in a suit holding federal identification still needed to prove something more. Think about this for a moment. You are a federal postal inspector with 18 years of service. You are standing in front of your own house. You have presented your identification, and you are still being questioned about your right to exist in that space. What do you do with that? How do you process the fact that the very system you dedicated your entire career to serving is the same system being used against you in that moment? Irvo Otieno didn't lose his composure, but what happened after that moment, what the officers did with the information they had right in front of them, is what transformed a baseless stop into a federal lawsuit with consequences neither. Officer could have anticipated that Sunday afternoon. There is a detail in the body cam footage that many people who watched the video cited as the moment everything became clear. It's not the moment of the initial stop. It's not the moment Irvo presents his credentials. It's a moment slightly after that, when one of the officers steps a few feet away and makes a call. He is verifying Irvo's credentials over the radio, requesting confirmation that the federal identification is legitimate, and while he waits for the response, he remains positioned in a way that keeps Irvo where he is, as though the possibility that this entire situation was a mistake had not yet crossed his mind in any real way. The confirmation came back. The credentials were legitimate. The man they had stopped was exactly who he said he was. And still, the stop did not end there. What happened in the minutes that followed revealed something about the mindset operating in that scene. Rather than withdrawing professionally, acknowledging the error, and ending the contact, the officers entered what investigators and civil rights attorneys describe as defensive escalation. When an officer realizes they are wrong, but instead of stepping back, attempts to find some retroactive justification for having initiated the stop in the first place. They began asking questions about other things, about Irvo's vehicle, about where he was headed, about details that had absolutely nothing to do with the original reason they had been dispatched. It was as though they were trying to find, in real time, some reason that would transform the stop into a justifiable act. Irvo recognized that pattern. 18 years investigating crimes that frequently involved abuse of authority and misconduct within institutional systems had given him an ability to identify irregular behavior that few civilians would possess. He knew what was being done. He knew he was being kept there, not because there was any legitimate suspicion, but because the two officers needed time to build a narrative that would make sense for the reports they would have to file later. And he stayed. He answered the questions calmly. Not because he was required to, but because every second of that interaction was being recorded, and he understood the value of that footage. The problem with defensive escalation is that it rarely ends cleanly. The more the officers tried to find a reason for having stopped Irvo, the more visible it became that there was none. The body camera kept recording. The questions kept revealing the absence of any legal basis for that stop. And then came the moment that attorneys would later describe as the most expensive mistake either officer had ever made in their career. One of the officers, with the camera running, with Irvo identified as a federal agent, with zero evidence of any crime, asked Irvo to place his hands on the hood of the car to be searched. A federal postal inspector, in the neighborhood where he lived after presenting credentials, confirming his identity and authority, was subjected to a physical search in front of his own home. Have you ever wondered what goes through someone's mind in a moment like that? Not someone who is afraid. Irvo wasn't afraid, at least not in the conventional sense, but someone who completely understands the scale of what is happening, who knows that this should not be happening, who is living in first person, the most brutal possible contradiction between what the system promises to be and what it demonstrates itself to be in practice. Irvo Otieno spent 18 years being the system, being the authority, being the side that investigates, that arrests, that protects. And in that moment, he was being treated as the opposite side, not because of anything he had done, but because of how he was visually read by two men who decided, in fractions of a second, what he represented. The search found nothing. Of course it did. Because there was nothing to find, Irvo was released with no charges, no formal record of any infraction, no official explanation for what had just occurred. The officers returned to their patrol car. Irvo stood on the sidewalk for a moment, and then he went inside. But before he closed the door, he did one thing that would define the next 18 months of everyone's life involved in that case. He picked up his phone and called a lawyer. The law firm Irvo Otieno contacted that evening specialized in civil rights and police misconduct cases. The attorneys listened to his account, asked him to describe every detail in chronological order, and before the call even ended, had already filed the formal request to preserve the body camera footage from both officers. That step is critical and frequently overlooked by people unfamiliar with the process. Body camera recordings have retention periods, and without a formal preservation request, they can be overwritten or discarded within days or weeks. Irvo knew this. His attorneys knew this. And the request was filed before anyone inside the Collierville Police Department had time to evaluate exactly what was recorded in that footage and what it might mean for the department going forward. While the attorneys worked behind the scenes to secure the evidence and initiate the formal investigation process, Irvo did something that amplified everything in a way the police department clearly had not anticipated. He went to social media, not to deliver an emotional rant, not to attack the officers by name or incite any kind of response. He posted a factual, straightforward account of what had happened, including the date, the time, the location, and a precise description of the sequence of events. He attached screenshots of his federal identification to provide context for who he was. And he ended the post with a simple question. How much longer? The response was immediate and overwhelming. In less than 24 hours, the post had tens of thousands of shares. Journalists from local and national outlets began reaching out. Civil rights organizations, including the NAACP and the ACLU, issued public statements of support and demanded explanations from the department. Other residents of the Collierville development began coming forward with accounts of similar stops they had experienced or witnessed in previous years, creating a pattern the department could no longer attribute to coincidences or isolated misunderstandings. The story of a federal postal inspector being treated like a mail thief in front of his own home had every element that transforms a local incident into a national conversation. And that is exactly what happened. The Collierville Police Department issued an initial statement that followed the standard script in these situations. Words like internal investigation, established procedures, and full context appeared in the text, with the frequency of an institution trying to buy time without saying anything concrete. The police chief did not speak publicly in the first few days. The 2 officers involved were placed on administrative duty, which in practice meant they continued receiving full pay while the situation unfolded. The implicit message of that institutional silence was the same as always. Wait for the noise to die down, for media attention to shift elsewhere, for people to forget. But this time the noise did not die down, because the body cam footage was released. And when the public watched that video, a man in a blue suit standing in front of a large brick house using a key to open his own mailbox, being stopped, questioned, having his federal credentials dismissed, and being subjected to a physical search. The reaction was of an intensity the department was not equipped to handle. There was no ambiguity in that footage. There was no camera angle that favored the officer's narrative. There was no way to watch that video and conclude that any part of that stop had been justified by any reason other than the fact that Irvo Otieno was a black man in an affluent neighborhood. Think about the weight of that for a moment. We live in a time when videos of police stops have become so common that many people have developed a kind of emotional numbness toward them. But this one was different, because this was not a case where there was any gray area, any element open to interpretation, any detail someone could use to construct an alternative argument. It was a federal agent, with credentials, in front of his own home, being treated as a suspect, with everything recorded in high definition. And when that level of clarity meets that level of public visibility, what typically happens with internal investigations that tend to protect their own, the quiet filing away, the discreet commendation of the officer involved, the conclusion that everything was done within procedure, simply was no longer a politically viable option for the department. The external pressure had created a situation where any outcome that did not involve real and visible consequences for both officers would be read by the public as confirmation of everything people already suspected about how these departments operate when they are being watched. The Collierville Police Department was cornered between the internal culture that tends to protect its members and the external reality of a video the entire world had seen. And it was at that point of maximum tension that Irvo's attorneys formally filed the civil action in federal court. The initial petition filed by Irvo Otieno's attorneys in federal court was a document of surgical precision. Every allegation was anchored in concrete evidence. Every violation was connected to a specific legal provision. The action cited the Fourth Amendment of the United States Constitution, which protects citizens against searches and seizures without probable cause. It cited the Civil Rights Act of 1871, known as Section 1983, which allows citizens to sue state agents for constitutional violations. And it cited federal precedents that established with clarity what constitutes a lawful stop and what constitutes arbitrary detention. It was not a petition built on moral outrage, though the outrage was entirely justified. It was a petition built on facts, chronology, and jurisprudence, and that made it extraordinarily difficult to contest. The police department hired an outside law firm to handle the defense, which in itself was a signal that the situation was considered serious. Internally, the municipal office that would normally handle this type of action was deemed insufficient for the level of exposure the case represented. The defense attorneys began with the most predictable strategy available, attempting to establish that the officers had acted in good faith based on a legitimate citizen complaint, and that the stop fell within the limits of what is permitted during a reasonable suspicion investigation. It was a weak argument against the footage, but it was the only argument they had. The problem is that reasonable suspicion has a very specific legal definition, and standing in a suit on the sidewalk of your own development does not fit any reasonable interpretation of that concept. During the discovery process, the phase where both sides are required to disclose relevant evidence and documents, Irvo's attorneys requested the complete complaint history for both officers involved. What they found was revealing not because there was an explosive pattern of documented brutality, but because there was a consistent pattern of small complaints that had never been taken seriously. Stops without clear justification, racially charged language in incident reports, complaints from black residents of the same neighborhood who had been questioned about their right to be in their own homes. Each complaint individually could be dismissed as subjective or inconclusive. Together, they formed a narrative that the defense attorneys could not unravel. The deposition phase was where the defense began to collapse most visibly. When Chandler and Samples were questioned under oath about the decisions they made that afternoon, their answers revealed an inability to articulate any coherent legal justification for the stop. When asked directly what specifically had generated reasonable suspicion to initiate contact, both officers gave responses that ranged between vague and contradictory. One said the way Irvo moved near the mailbox seemed unusual. The other said the neighbor's complaint was sufficient on its own. When Irvo's attorney pointed out that an anonymous complaint without specific details of a crime does not constitute probable cause or reasonable suspicion under established federal jurisprudence, neither officer was able to respond satisfactorily. What made the depositions even more devastating for the defense was the moment Irvo's attorneys introduced an element the department had clearly not anticipated. They brought in use of force and police procedure experts, veterans with decades of experience training officers, who analyzed the body cam video frame by frame and produced detailed technical reports identifying every moment the officers deviated from established protocols. It was not Irvo's word against the officer's word. It was specialized technical analysis stating, with precise terminology and reference to specific departmental guidelines, that the stop would not have been justifiable under any scenario that did not involve a prior assumption of guilt. And prior assumptions of guilt based on racial appearance have a legal name. It is called discrimination. The city of Collierville received from the law firm hired for the defense an honest assessment of where the case stood, and that assessment was brutally clear. The chances of winning at trial were minimal. The video was incontestable. The officer's history was problematic. The experts were credentialed. And the potential value of a judicial verdict, should the jury decide in Irvo's favor, was significantly higher than any number the city could offer in a settlement negotiation. The city's finance department ran its own calculations. The legal department ran theirs. And both arrived at the same conclusion that is invariably reached when the evidence is overwhelming and the plaintiff has the resources to go all the way. It was time to negotiate. The question was no longer whether there would be a settlement. The question was how much it would cost the taxpayers of Collierville for two officers having decided that a black man in a suit picking up his own mail looked suspicious on a Sunday afternoon. The settlement was finalized months later, and the full amount was never officially disclosed. But sources close to the process and partial public records indicated the figure was in the range of several $1 million. It was not the kind of number a city the size of Collierville absorbs without visible budgetary consequences. It was the kind of number that appears in city council discussions, that generates questions from taxpayers, that forces conversations departments would prefer never to have in public. And that was precisely why Irvo and his attorneys accepted it. Not because they needed the money to survive, but because $1 million settlement paid with public funds speaks a language that politicians and municipal administrators understand far more viscerally than any speech about human dignity or equality before the law. Beyond the financial figure, the settlement included a series of non-monetary requirements that Irvo's attorneys had insisted on, including from the beginning of negotiations. The department would be required to implement a revised implicit bias training program with periodic evaluations and external audits of results. An independent complaint review system would be created, removing from the department itself the exclusive power to investigate its own conduct. Body cameras would be subject to stricter data preservation protocols, with specific penalties for any tampering or loss of footage. And both officers involved, Chandler and Samples, would be terminated with no possibility of rehire by the department or by any other public safety agency in the state. That final clause was the most contested during negotiations. The police union fought fiercely to keep both officers employed, or at minimum to ensure the termination did not come with a permanent notation that would prevent them from working at other departments. It was the same argument as always, that termination was a disproportionate punishment for an error in judgment, that the officers had families, that they had years of service, that they deserved a second chance. Irvo's attorneys responded with a simple question: a second chance to do what? To stop another federal agent in front of his own home? To treat another black resident of an affluent neighborhood as a suspect with no evidence of a crime? The clause remained in the settlement. Both officers were terminated. Chandler and Samples attempted to contest the terminations through the arbitration process guaranteed by the union contract. It was an effort that lasted several months, and that, according to people close to the process, cost the union a considerable sum in legal fees. The arbitrator who reviewed the case examined the body cam footage, the expert reports, the deposition transcripts, and the complaint history of both officers. The decision was delivered in a 42-page document that detailed, with a precision that left no room for alternative interpretation, why the terminations were not only justified, but necessary. The terminations were upheld. The law enforcement careers of both officers had ended on a Sunday afternoon in front of a mailbox in Collierville, Tennessee. What happened to Irvo Otieno afterward is, in some ways, the most important part of the story. He went back to work. He continued being a federal postal inspector. He continued living in the same house, in the same neighborhood, using the same key to open the same mailbox. He did not move away. He did not request a transfer. He did not disappear from the community, shamed or traumatized into isolation. He stayed, and that in itself was an act of quiet resistance that did not go unnoticed by the people who followed the case, because the implicit message of staying was clear. He belonged there before any of it happened. He belonged there while it was happening, and he continued to belong there after. No unlawful stop, no lawsuit, no amount of institutional embarrassment had the power to change that fact. But Irvo did not stay entirely silent either. In interviews given after the case concluded, he said something that stayed with those who heard it. He said the case was never about him specifically, that he had resources, knew his rights, and knew exactly what to do the moment things began to go wrong, but that for every person in his position who has those tools, there are hundreds who do not, who are stopped the same way, treated the same way, humiliated the same way, and who simply swallow it and move on because they don't know they can fight back, or because they know that fighting back carries a cost they cannot afford to pay. He said he won the case for them too, and that he hoped the outcome would serve as a reminder that the system can be held accountable, but that for that to happen, someone must have the courage and the means to demand that accountability out loud.
Truth is a continuous pursuit, and awareness is your best defense. Thank you for watching and championing global transparency.